Prime Minister.
Should I sit at the end or get off?
Well, I don't think we'll have enough room if Chris shows up. That's all.
So get
Janice
off.
Payne.
Might as well
How are
get
you?
off. That's the only thing I can say.
Yeah, no, only talked on the phone.
Just on the
You're gonna read the questions
Yeah, I think
out.
only on the phone.
Let me read the questions on here. Yeah. Apparently there's 15 people watching it on our
So what does that put the whole thing up to? 206 or something?
more. You can have like 5 people in the office watching it. You can watch this on your computer. Yeah.
250.
Right.
Which is the way street. Similar vintage. When we started,
Yes.
Who paid? Who coded in? Who coded in? Who coded in? Who coded in?
Yeah, and it's a
Yeah.
Friday.
Welcome.
but inside, for instance, is a Canada law book that are doing super conferences. Put the money into it because it's in 20.
Well, they had an excessive turnover this morning.
Yes, I know.
Really good. Really good for the first half. And I just lost them. flat.
Give him my best. Why don't you move one closer, Barry? Where do you want me to sit? Right here.
I think
Barry.
there's only for the 6 NDP is one. And
So you talk to Tommy on a regular basis? How is he doing, him and Ruth? How is Ruth and him doing in practice? That's great. He's a great guy. So say hello for me.
Barry, move over one. Move over one so Paliare can
Yeah,
take
yeah.
the seat.
There's nobody else. Okay, I thought there was one more.
Yeah. Okay, nice
Thank
to
you,
talk
everyone.
If he comes, I'll leave.
We're going to start with the senior practitioners panel. Thank you. We have a number of questions. Hopefully we'll be able to get to them. Timing doesn't always work as we plan it. Mr. Paliare's not here yet, but hopefully he'll be here shortly. In the meantime, the esteemed Mr. Fisher, who is going to join us, apparently he told me he needed an excuse so he didn't have to go to a craft show with his wife, so we provided that for him.
I'm saving a bundle by being here.
The panelists I haven't introduced today is Peter Israel. Of course, he needs no introduction. He is the Employment and Labor Counsel at Goodman and Carr. As you all know, he has been named frequently and as with Lexpert. He's been an opponent of mine for, I guess, 25 more years. The first case we had, I pulled an interesting trick is that he said to me, "Oh, this matter won't get on for years." I said, no, look where I started the action. And he looked and said, Newmarket. I said, it's on for trial next month. Those good days are gone, but venue shopping was a lot of fun in those days at the outset, and Peter was so smug at the beginning, thinking, oh, this is just, I'm going to have to settle. But no, Peter had to settle, and it was a lot of fun. And Mr. Paliare, who hopefully will be here shortly, again needs no introduction, and his CV is in the materials. He's been on the panel for many years and offers lots of variety and comment, and so I hope he'll be able to join us. We've done a few questions, and then we'll get to the questions from the audience. The first question deals with sort of the theme of negotiations. A review of the file indicates that you're likely to get an award. You've done all your research, you've used Barry's database, and you're going to likely get an award of 8 months total compensation and potentially a Wallace bump. The individual earns $100,000 a year. But was only offered a 3-month lump sum at the time of the termination. The difficulty is the individual is highly marketable and may be able to mitigate his damages very quickly. The opposing counsel responds to your initial letter by indicating that it's a take it or leave it proposition, and kindly you have another 5 days to accept or the offer's off the table but for the employment standards. What strategies would you follow? The first question is to Mr. Israel.
The only thing that troubles me about the fact situation is that your client might be able to mitigate very quickly, and that alters the situation. What I've done in situations like this before is either agreeing to a voluntary mediation in front of somebody like Barry, if one can. I've been able to successfully negotiate for a continuation of his salary, at least for that 3-month period of time, without prejudice to his asserting a claim later on. And In this kind of situation where mitigation might well work to the advantage of the defendant, I think the defendant might well be in a position to be willing to agree to that kind of proposal, especially since if he's entitled to 8 months, there probably would be an employment standards minimum that might well be close to the 3-month period. Lastly, what I've done before in situations where the defense counsel is sort of very, very bullying and very, very aggressive is to tell him or her that I have decided in the circumstances to take the case on a contingency basis, and therefore their card which indicates that they will simply make it expensive and drag it out sort of disappears or is reduced.
Barry, you're going to have to stand in for Chris.
All right. So the question is, what do you do when you have a really difficult defense counsel who's going to make your life miserable?
And
Sorta.
you're,
Yeah.
that would be the situation.
All right. Well, I think there are a couple rules. And the first one is KISS, keep it simple, stupid. People who want to drag plaintiffs through the mud and everything try to use all the procedural wrangles they can, so try to avoid the procedural wrangles. Leave the law times torts for another case, keep it simple, and go straight. Go as quickly as you can. With case management, you can force things on really quickly. Skip discoveries. There are numerous steps plaintiff's counsel can take to move a matter quickly to trial, avoiding the sidetrack that the defense wants to suck you into. When I used to, as defense counsel, the best thing you can do is lose a motion, because then you get to appeal it. So that's what I would do. Keep it clean, keep it simple, because as the trial approaches, you're more likely to have a rational discussion, because those types of defense are being told, don't worry, you'll never have to go to court, we can delay him 3 years. The late Mr. Paliare is right.
Chris, thank you for joining us. This question we were dealing with was on the concept of negotiations, on the individual who was being undersold by difficult defense counsel, and what tactics you might use. And one of the things that I thought that you might do in this case is not get hung up. If you're dealing with a defense counsel who is being difficult, and this is the time where you get on the phone and you invite yourself over, especially if it's a large firm. They usually have fairly good coffee and good cookies, and invite yourself over and size up the situation. You know, leave a few hints that, you know, even though your client, you know, may not mitigate as quickly as they think, that it could come back to haunt the defense counsel. But you want to be on the defense counsel's turf. So there's nothing the matter with going over and visiting defense counsel, and even suggesting you're coming with your client, and perhaps they should bring their client along as well. So there's some tactics you can use early on to try to move it out of this, and let's not call it necessarily a bullying tactic by the defense, but you know, you don't know if it's the lawyer who's being difficult, you don't know if it's the company that's being difficult, so let's see if we can get on their turf and find out just where the picture is. Chris, do you have anything else to add?
No, I don't disagree with any of that, and I've done it often, and it really is useful to go to their offices. Somehow it gives them a feeling of importance and significance that they probably don't deserve, but that, but it is different. I mean, I don't care how senior you are, you're better off going onto their turf. The other thing is, though, in that situation, if that doesn't work, I'm very big on getting a statement of claim out immediately and letting them know that you mean biz, and that these things are not like good bottles of wine. They really, really don't get better with age. And that if they see you mean business and you've got it on an expedited track, I just think it's worth doing if the defense counsel is really underselling the case that badly.
Malcolm or Janice, anything you want to add?
Two things I want to add. One,
A little closer to speak.
in terms of, I'm coming back to the mitigation problem in the fact scenario, which would trouble me, and the inability to tell whether the difficult party is counsel or the client. One tactic you might think about is an attractive lump sum offer that the lawyer will have to show to his client. And if in fact it's the lawyer that's causing the difficulty, it may just be that the offer will be taken. I want to tell one quick story on the subject of how to disarm counsel. Remembering back to Justice Randy Echlin, whom we heard from this morning. My first encounter with him, I sent off one of my letters, acting for a plaintiff, and I got a call from Mr. Echlin in Toronto who said, you know, this is who I am, and I've asked a couple of my colleagues about you, and I understand that notwithstanding the utterly outrageous things you said in your letter, that you're quite a reasonable person. So I'm hoping we're going to be able to have a conversation, and we did, and always did. So it's something, the personal touch. Sometimes all that carrying on is because you don't know each other very well, and the personal touch can make all the difference.
Yeah, and I really think that's what Mr. Justice Echlin was clearly underscoring this morning. Malcolm?
I think that as plaintiff counsel, it is really your obligation to bring it on as quickly as possible. And I think that I strongly agree with Chris's comment that, you know, going over for coffee and cookies is a good thing, but you should have your statement of claim in your back pocket and ready to go. And I think I'd just take it up one more step, is that in a case like this, what you want to try to do is meet the employer's concern that there's going to be a quick mitigation. And obviously, I think the objective here would be to try to get a bridging formula put in place, right? So you have a continuation of salary with a modified bridge. I think as plaintiff counsel, to me that looks like a compromise. I can understand why it would be difficult for defense counsel to say, I'm not going to give you 8 months because I think you're going to get a job. So once you hear that, you've got to address it. You can't just keep going back and having coffee and cookies and expect that all of a sudden the world's going to change, because it's a valid concern. I think it's a valid concern that they don't want the person to get a huge windfall. So how do you address that? You address it by coming up with an option that makes sense, which is a modified bridge, which is good for your client and good for the employer. But I'm a strong believer, get your statement of claim issued and also serve an offer to settle with it. And then consider a summary judgment motion. And if it's just a notice case, you might be able to get it on through summary judgment.
Turning to a topic, Malcolm, that you're not familiar with is just cause. Chris, in your absence, we've been voting on one of Malcolm's files that he's going to trial with Brian Mulrooney on, so you'll get to vote at the end of this panel, too.
Can I just add something? For all those who voted in favor of Malcolm last time, how many of you did it because you didn't want to disappoint him? Okay? If we count those, then you lose.
Or hurt his feelings. The initial termination letter indicates the termination is for financial mismanagement, although not theft or fraud. The terminated individual is the chief financial officer. There's an extremely low offer to settle in exchange for a full and final release. How do you draft the first response as plaintiff's counsel?
Can I just say something before we go any further? Peter Israel has put him up to this question, because Peter and I are involved in this case, and the only way he can get me to talk to him about this case is in a panel discussion, which I find just questionable, to say the least.
Well, it wouldn't be just cause to fire us from the panel, though.
Answer the question, Malcolm.
See what I mean?
All right, Malcolm, you're on the hot seat.
What's the question?
Well, you know the facts. It's your case.
It is, isn't it? Yeah. So you want me to answer in terms of the response? What response?
How would you do as plaintiff? I'm going to switch to as plaintiff. What was the first letter you're going to write to yourself?
See, now, how bad is that? They're making me flip sides on this case.
Well, that's what Caplan told us this morning about how you get a good mediation going. You ask the employee and employer to flip positions.
Malcolm, here are the questions.
The challenges I would see it as a plaintiff in a case like this would be to get the other party to discuss the issue, and I think I would. This is a case where you have a CFO who is responsible for all of the financial management of the company. So, you know, when I take on a plaintiff like that, and there's allegations of misconduct, I generally am concerned about, you know, the current environment that we're operating with Sarbanes-Oxley and Enron, and so I generally tell the plaintiff that, you know, you've got to make sure you're very clean in terms of what you've done. In this particular case, my view would be that you've got to try to separate. What the employee actually did himself, if anything, and what he's responsible to make sure doesn't happen within his organization. And that's an issue. And I would try to convince counsel on the other side, Peter, as defense counsel, that, you know, this isn't a case where you've got somebody digging into the they're putting his hand in the till and getting money for his own benefit. It's really a case of financial mismanagement, and it may or may not be any intentional act on his part. The best case you've really got is a case of negligence and incompetence, not theft, and you shouldn't worry about the corporate governance issues.
Janice?
The first thing I'd want to make sure I had is particulars as to exactly what the alleged mismanagement is. So I think I'd start with insisting on some level of disclosure of that. Then I'd sit down with my guy and go over what the allegations are, get his version on it, try and assess the real risks. Like Malcolm, my attitude probably will be it isn't exciting in the context of a real case for cause. I would respond and say there is no cause. We'll be pressing for Wallace damages if you persevere, and let's get on with it and explore the notion, because I often like to, of a voluntary mediation to see if we can get the discussion going.
Mr. Paliare?
One of the things I'd want to know for sure is whether the person in question was a CA. I'd want to know about, or whether he or she was regulated in some other way, because there will potentially be other ramifications if in fact there have been financial misdeeds. And so it may be that in the context of looking at this holistically and getting on with life, it may be that on those facts, on the facts as I understood them, I don't think there's any cause, assuming that these are matters that had not been brought to the person's attention in the past and there had been no warnings. So it struck me that if, on the other hand, there is, I don't know if any of you have ever been to the Institute of Chartered Accountants, but coming to the Law Society is like a walk in the park compared to going there. I mean, they are outrageous. I mean, I think they prosecute accountants if they do financial statements with a broken pencil. You know, I mean, it is a place you don't want to be in, and the appeal process is Byzantine. The time, you wouldn't have the time, energy, effort, or your client's money to get you to the divisional court by the time you worked your way through the internal appeal procedure. So you really want to look at it contextually to say, you know, what do you want out of this? And if, in fact, the employer is asserting mismanagement, are they also perhaps going to report this person? And if so, can you work out an arrangement whereby A, there's no reporting, B, you get some dough, and C, you get on with life? So I find these cases difficult because viewed solely from a employment law context, I just think it's an easy case. It's a slam dunk. It's ridiculous, and I think I agree with Janice that this is a Wallace kind of case. If you're making those kind of serious allegations and alleging cause against a CFO, there doesn't appear to be anything here to indicate that the CFO benefited personally. So those are just some, as my kids would say, random thoughts. And I apologize for being late. I had to get in, and anyway, I apologize.
But you see, that's what prompted my question to Randy this morning, because the other side and the flip side of the coin is that, notwithstanding that it's a slam dunk, and I agree that it is, it's a slam dunk that is going to take 2.5 years or 2 years to reach fruition. There is a cloud over the individual's head, which indicates that he's financially a mismanaging type of CFO, and it may not help him in getting a job. And so it becomes a much more difficult exercise. And I think from a plaintiff's perspective, you have to be willing to reduce the expectations of the plaintiff somewhat in order to get the intangible benefits of a letter of recommendation, of assistance in being able to mitigate. To complicate the factors, though, or to make it easier for at least Chris's position, if I were to add the fact that there is an employment agreement which provides for a 2-year severance package without mitigation obligations, it might make it somewhat easier to stick out that period.
Why don't I get those clients?
You had
This one.
You had Kilpatrick. You
Malcolm
don't get
on the
enough.
other side.
And the way he deals with the cases, there's votes. Barry, I'd like to, if you're having heard from everybody, give us sort of the mediator's perspective.
I sit down with the employer and said, you know what? This is an interesting case. If you win this case and you prove that your controller for the last 5 years has mismanaged the company, then the headline in the report on business will be, public company succeeds in proving they've been mismanaged for the last 5 years. Yes! And then the guy I'm giving instructions from says, do you think maybe the stock price will go down? So I paint a bad picture of winning. This is what winning looks like to the company. Now, if it's not a public company, it's not nearly as helpful. Or I say, well, you've alleged financial mismanagement. Under the SEC regulations, you've of course reported it. Not yet. I see, okay. So usually when you dig deep, you find out there are a lot of adverse consequences to winning. Play that out, let the man get on with his life, and that's how I try to bring about a resolution.
Yeah, I've had that case in the reverse, but for lawyers, and it's very difficult when you want to be a law firm and allege cause, because then you want to determine what files you've all mismanaged.
Yes.
Turning to the hot issue that used to be hot issue, now that the market's rising again, of stock options. What do you do with that case? We all know Veer and Dover, and we all know that a number of years have now elapsed, and employers are fixing their stock option agreements to comply with the Court of Appeals directives in Veer and Dover and the cases that have followed. So what do you do now when you're sitting with a termination? The stock options have finally gone up after 3 or 4 years, and there's, the reasonable notice is worth $40,000 and the stock options are worth $500,000. What kind of creative issues do we now see that are available to us? Who wants to take a tackle at this? Chris?
Yeah, I don't think Veer will stand the test of time in this sense. I think it was one step in a two-step process. That is, it was the first step in overcoming the Matthews decision, but I have the sense that if push came to shove, that the Court of Appeal would go further than Veer, that it makes no sense to me that somebody who is given options over an extended period of time, and it's clearly part and parcel of their compensation. You take any one of the financial institutions, any one of the banks, every letter they get says, thank you for your contribution last year, and your compensation this year is going to be made up of 3 parts. Your base salary, your bonus, and your stock options. That's what the letters say. And so if in fact you're true to the principle that when you terminate somebody, they're entitled to full compensation on a go-forward basis, how is it that 1/3, and it's usually more than 1/3 of the value of that person's compensation, somehow gets lopped off? I just don't buy it in the long run. I think that if in fact somebody's entitled to 12 months or 15 months of total compensation, it's got to include the options that would have vested in that time frame, regardless of what the plan says or regardless of the way in which people are trying to draft these agreements. And I got one of them coming to trial in April, and I'm going to roll the dice. I don't buy it. I just think my guy is going to win this. And if he doesn't win it at trial, we're going to win it at the Court of Appeal. I just am wedded to this concept that it is nonsensical to suggest that somehow the wording is going to keep somebody from getting their full value.
Malcolm?
My response is a contract is a contract is a contract. And the problem with that decision was that, and if you look at why that decision made sense, is because it wasn't clear in the plan as to the circumstances upon which those rights could be extinguished. And so a lot of companies who extend options also have provisions about non-competition. And there's also plans to deal with SERPs that deal with executive pension plans. And again, if you get those enhanced benefits, it's subject to non-competition or non-solicitation covenants. And my view is that you have to go back to what the deal is. If you, and it's no different than if you are saying to somebody that they have a car allowance for a certain period of time, or that you have a car allowance of $800 a month, $1,000 a month, but it does not continue after you're terminated. I mean, you can specifically write that into a contract. And the Chris's position with respect, I think, it takes the right that parties have to negotiate a deal when they come in. I totally agree with Chris's position. In the absence of clearly worded language with respect to the restriction, then it should accrue during the notice period like everything else does. But if you have language that says these rights are extinguished upon the effective date of your termination, or whatever the proper language would be, then I don't think they accrue. And I think it's purely a matter of contract interpretation by the courts, and it's similar to any time that the parties agree to a termination clause. If the parties agree to a termination clause, provided that it is consistent with the Employment Standards Act, a court shouldn't interfere with that.
I guess the variable sometimes occurs, Malcolm, when you have the plan document, but then you have the sales pitch, which occurs every year, just as Chris was saying. Here's the sales pitch, you're a great employee, you're terrific, and here's all these options. So there's a contradiction between the sales pitch to keep you a happy employee and the plan document. I saw one the other day which literally says, and it's like in bold letters, during your period of reasonable notice, these options are dead. And it was almost that explicit. So, Peter?
Yeah. Normally, I would agree with Malcolm, actually, in terms of my practice, but I've been doing a lot of plaintiffs lately. And so,
And he's been watching the stock market.
so I agree with Malcolm, though, in terms of freedom of contract, but I very much agree with Chris's position, but I twist it around a little bit. I think you're going to have to find a different hook to give to the court, and the hook can be a lack of consideration, bad faith, inconsistent application with respect to people they like, where the trustee always has the option of extending, but in this case they're not willing to extend. So you're going to have to go back to some kind of contract arguments, as opposed to the argument that Chris at first blush at least put on the table.
I'm not sure I disagree, and you see, I may not disagree with Malcolm either. If, in fact, it's clearly stated on the way in the door that this is going to be your deal, those are more difficult cases. But cases I'm talking about are ones where the deal, the plan changes, the employee is there, the letters that Barry and I have talked about, the sales pitches come in and appear to be different than the plan. I think those are going to be problematic for the employer. If, in fact, the plan is clear from the beginning and it's made clear to the employee that you're not going to get these if you're terminated, regardless of whether it's with or without cause, all that stuff, and they never change the plan and they don't give out any letters, I think that's a more difficult case. They just don't happen, generally speaking, because employers want to induce employees to stay and remain, and they end up writing these, and they depend on the options to keep good and valuable employees, and so they end up, I think, causing themselves an enormous amount of difficulty, and I think a hook that Peter talks about to assist people like me who don't do this kind of defense work that you guys tend to take because it pays the rent on a regular basis. I think from a plaintiff side that is going to be problematic for employers.
I think what I have seen since that case, a lot of companies have done their best to stopgap these arguments, and they've made changes to their plan. But I think I agree with Chris and Peter that you have to look for something outside the normal contract. Just to simply say, well, everything should accrue during the notice period, regardless of what's written down, is not good enough. And the first place to look, I think, is the difference between the plan and the actual hire letter, or the conduct or the conditions that are attached in a letter granting the options. And there's always inconsistency because some manager hasn't really understood the practice, and then the minute you can show some inconsistency, whether it's a misrepresentation or an oral misrepresentation or a written commitment that looks different than the plan, I think you're home free. But I think that those are going to be harder and harder to find, because I think companies have done a lot to try to straighten that up.
Janice?
It seems to me that if it isn't clearly spelled out in the employment agreement that you lose these things when you're terminated, that you're at least halfway there, and it strikes me that there isn't much difference between that scenario with stock options and the bonus situation, where I think we all say, look, we don't care if we're acting for plaintiff's counsel that the bonus plan says you don't get it unless you're here. We always say, no, that would have been there had you given me working notice, and so these are the damages that flow. And I'm only happy to hear that Chris is taking something forward, because we clearly need it. We need some clarification on it. The state of the law at the moment isn't terribly helpful. The only other thing I want to add is that some employers don't just assume if the plan reads in a way that isn't favorable that you can't deal on the options. Some employers will deal on the options. Some employers will accelerate options and vest them in exchange for concessions on the severance package. So don't assume that isn't possible till you try it.
And remember, the stock issue is tax-advantaged money, which is very favorable. Barry, this is a tough case if it's before mediation, because the stock values, the severance is literally worth $50,000 or $60,000, but the stocks are worth $500,000 because of what's happened. How are you going to handle that at a mediation?
Depends on what the timing of the mediation is. If you're doing a mediation within the notice period, which happens very often I'm in there within 4 months, the employer may still have the option to simply give the options, not give any money. And when you actually enlighten them on that, just give them the frickin' options. Hopefully they haven't shut it down and it's out of Maryland and anything like that. Because I'm not an accountant or anything, but from a cash point of view, it costs them nothing. They've already allocated, it's there. There's some sort of dilution thing off in the distance, but the money's not coming out of that manager's budget. So I explore whether you can just give him the options, him or her the options. That's not feasible if you're well beyond it, but it's at least an option to look at. Otherwise, it's a whole lot of money. It's contentious, and hey, that's why mediations result in resolutions. The difficult one is they get passionate about it. It's like the bonus issues, and the farther south in the United States that clause was drafted, the more...
In particular, Texas.
Oh, Texas, Jesus, West Texas, the West Texas lawyer speech. The harder it is, and God forbid, counsel defending it is the one who wrote the piece of shit. That's always extremely difficult problem. So hopefully it's somebody in Alabama that wrote it or whatever and all that. But it is a highly emotional issue with employers. So unless it's worth a lot of money, if there's a lot of money, you can't avoid it. But if there's not a lot of money in it and it's highly important to employers, say fine, whatever. Then I'm going for extra notice, because you're right, you'll probably win on that technical issue, and the judge is going to scratch his head, okay, how do I somehow give this guy an extra $100,000? Oh, Wallace, fine, I'll call it Wallace. So look for the other hook, look for the other excuse. But bonuses and stock options are like emotional things for employers. So go for the easy money. If it's $300,000, I mean, you got to go for it. So.
There was a question from the floor?
The new accounting rules went into effect this, where bonuses, or I'm sorry, options have to be treated as salary, like your reporting, things like
from accounting, what the question is, are there new accounting rules, as I understand it, which now says the granting of options has to be shown as an expense? Probably yes. My hope is that most employers don't know that. And more importantly, the manager who's still doesn't have to write a check. And in large organizations, it is remarkable how they often actually don't care what it costs. It's where it shows up. So if it's some sort of mythical expense thing on the balance sheet that nobody really understands, as long as that manager is not being asked to write a check, it's probably not a problem. But you're right, there is now a more direct accounting cost to allowing an option to exist.
I'm going to take a question from the floor. In the material, because the question starts, "'Tis the season of the office party," so we know where this question is going. And the question really evolves around the issue of the duty of the employer at office parties so that you don't find yourself into sexual harassment issues, and more importantly, the whole issue with respect to alcohol, and perhaps more of an insurance question in terms of employer liability, in terms of letting someone out the door who's had too much to drink. Any comments, guys? Chris?
What's the question?
The question is, what is the responsibility of the employer at their traditional office party when it comes to the too much alcohol, or hopefully just alcohol?
I think in this day and age, the employer's obligation is high. I just think it's a serious mistake to think that the days of the 60s and 70s and 80s when people could just drink and carouse and leave the ballroom of the Royal York and go up to 1502, are just aren't.
Just bring back memories, or why 1502?
Is that the one with the heart-shaped net?
Skip that.
Erase the tape on
Just aren't on anymore. I think it's.
This is exactly the question. They said 1502 in the question.
How did they know? Same party. I think it's when you look at the case in which the employer got whacked with the damages for the woman who was drunk before she got to the party, had more to drink, and then got into her car and got into a serious accident. And I know it got overturned by the Court of Appeal, but it lets you know what the risk is out there and what the thinking is of judges. And I just think that you're just playing with fire. If you don't, on the driving side of it, of course, you got to be giving everybody cab chits home. Cab chits to the place, cab chits home. Don't let anybody drive home. In terms of the sexual harassment, I think you got to be careful. And you also, though, it's dangerous. But if in fact that kind of conduct occurs, I think as an employer you got to deal with it swiftly, and you got to deal with it as soon as it comes to your attention, and you can't pass it off as being, oh well, it was the Christmas party, or oh well, it was just Bill. Everybody knows Bill the groper. No, but you laugh, but that sometimes gets to be the attitude of employers, and that's how they get into trouble long term. Is that you can't let Bill the groper just carry on doing that anymore.
Be fair, Billette was there too.
What's that?
Don't let Billette either.
Oh, yeah, right.
Peter?
For a long, long time now, we have provided all clients with a list of how-tos so that you can show due diligence, so that you have an actual checklist of what you do at an office party in terms of exactly the points Chris raised, in terms of who can drive, who can't drive, arranging for buses, arranging for taxi cab chits, ensuring that there is an enforcer on the premises to make sure that nobody takes a car. And that kind of stuff. In terms of sexual harassment, the same thing. So I guess I'm not saying anything new. You have to have your policies in place. The people have to know who they can complain to. Whenever there is any kind of complaint, you of course immediately investigate. What we've started to do, and it's paternalistic and horrible, and I don't like it, but it's one of my roles, for instance, at office Christmas parties, that I hang around to watch. And I'm old enough that I can be a parent. I no longer go to room 1502. You simply are there to make sure that nobody gets totally carried away, at least on the premises, which are under your control. And the law is clear that a Christmas party is the workplace, and so the same liabilities.
How do you break up these amorous tete-a-tetes at the party, Peter?
I usually call you, Chris.
That's why they call him the bouncer.
But isn't that the easy answer is just invite spouses?
Or you have a children's party. But I think Peter's the solution. I mean, I think we have, as employment lawyers, we have a responsibility to make sure our corporate clients understand that they really have to lay down the rules very carefully going into these parties. I'll never forget, I had a client who did a kickoff party. It was the salesperson who won the prize and had the most sales was going to get a trip to Paris. So of course they had 15 scantily clad people dressed for the can, did this for an hour, got everybody really drunk, and wondered why they got in trouble when their salespeople went out to a bar and were groping the waitresses, and they couldn't understand the problem. So those days, fortunately, have passed, but I think corporations have to have a clear understanding of the rules. Janice, anything?
No, not really. I think the notion of getting out to corporate clients what their obligations are is good. It sounds like we all do it. We usually talk about chits for the bar and closing the bar early, too, before people, at least some stretch of time before people are expected to be leaving. But if you've got it covered off with no cars and taxis, we're still at the point where we don't oblige taxis. They're made available, but we haven't gotten as far, and I don't think most organizations have, of actually insisting on keys and no cars. But I don't disagree with what I've heard. I think it would be prudent.
Anything to add, Malcolm?
No.
I think the summary is you must treat your employees like children. It's actually, when you listen to this and you think back, it's almost sad, isn't it? We talk about respect in the workplace and everything, and that all these little rules it's really treating people like children.
It's probably good advice for your corporate clients to make sure that there's communication before parties start. And so I've got a number of clients that actually do that, and some of them take it over the top in terms of sending out the sexual harassment policy and along with the drinking policy and then the respect in the workplace policy, and all the employees get bombarded the week before Christmas, and so everybody's so depressed they don't go to any parties, right? Yeah. They figure they can't walk out of the house without misbehaving. So but you know, there's probably some merit in terms of advising clients to communicate on the front end in terms of what the rules are, and you know, joking aside, you can do it in a very professional way, and in terms of just sending a message from the senior executive saying, you know, we expect people to have respect for each other and have a good time, but be prudent in terms of your drinking and your dancing and blah blah blah. But you know.
Well, we didn't go to dancing, but obviously you had something in mind, Malcolm. The next question, also from the floor, is actually an interesting question, and it poses the idea of when do we think it's appropriate to serve a jury notice? And I might turn to Malcolm for that to start with.
I think in any plaintiff case that is sympathetic on its facts, serve the jury notice. And if I've done a few of them now, and it's just so fun to do a jury case. And I mean, as a defendant, I don't know many cases that you'd ever do that. You know, like, but as a plaintiff, you know, you want to make somebody sweat, you serve a jury notice, and because you just never know. And I had a 40-day jury trial a couple of years ago, and one again last year, and I swear to you, no matter how good the evidence goes in, you never know until the jury comes back. And as a plaintiff, I think that's a lot of leverage. And as long as your person shows up good. However, I have this case now with Harvey Strasberg, which is Harvey's not in the audience, but this is a.
But he may be listening on Bar X.
Harvey, get your ear away from the. But he's representing a president of a company who is alleged to have taken a business trip. The defense is that he took a unauthorized trip with his family that he took to Scotland and then Ireland and brought his mother, his wife, his 3 kids, and charged it to the company. It was like $60,000, right?
Sounds like a liberal cabinet
so-
minister.
So his position is that it was authorized and blah, blah, blah. He serves a jury notice in Kitchener. And I'm thinking everybody in that on that jury will, you know, likely make, you know, 30 to maybe 80,000 a year, the average person 100,000 a year. And how much sympathy are they going to have for a president who was making 500,000 a year, who took one trip that exceeds what they make annually? And, you know, again, you know, you got to pick your cases. And Harvey's an incredible litigator and very versed in all this stuff. But, you know, I sat back and I wondered, why would he do this? Like, what is it that would motivate him to go to Waterloo to do this case in front of a jury? And I think probably
Contingency fee?
Yeah, but probably the most significant motivation is the uncertainty. He probably thinks that in front of a judge, he wouldn't have as good a chance as he would in front of a jury. So, but you know.
Judges charge on ranges? Do they charge on near cause?
Yes, they do.
No question.
Right.
Repeat the question.
Do judges charge the jury with respect to range?
Not near cause.
Yeah.
Not near cause.
No, near
Near
cause,
cause.
near cause doesn't exist, so
Near
they
cause
can't
doesn't
charge
exist.
it.
Yeah,
They-
they do.
It sounds like what Mr. Strasberg has in mind is he's going to do better with a jury than
Right. No, as you know, the counsel makes submissions to the judge to help him with the charge, and the charge is made, and it would clearly, if that was an issue, it would be certainly for the counsel to make it in the submissions that, you know, after acquired cause or near cause doesn't apply.
Peter?
Yeah. The only kinds of cases where I've put in a jury notice on behalf of a defendant would be Malcolm's first fact situation, where you really think that a jury would find the hiding, the two $4,000 checks, the clothing allowance to be sort of weird. The other kind of case as a defendant where I've put in a jury notice is when a senior employee who is accused of sexual harassment, for instance, and gets terminated, sues for wrongful dismissal. And I have, in that kind of case, put in jury notices on behalf of the defendant, because I don't think a jury would be anywhere near as accepting as some judges are, or used to be. I don't think they are anymore, of that kind of conduct on the part of a senior employee. I'm thinking of like Bannister or do that kind of case.
So I wouldn't go to a jury on that. I agree with your first example. I think that's a great example. But on the, I think on a sexual harassment case, I think a judge is going to more likely find in favor of a company than that's what I would think. Chris, I don't.
I agree with you totally. That case, that Windsor case, that
Right.
Ford case,
Yeah.
I mean, they judges are tough on that stuff.
Right.
Now they are.
Yeah, they are these days.
Yeah.
Janice?
I have to say, I tend not to use them, and I don't see them used hardly ever in Ottawa. There's one exception. Recently, we're dealing with a rather odd decision that came out of a judge and jury situation. But I'm always bothered from the plaintiff's point of view as well with the lack of certainty, and find that most plaintiffs want some better predictability about their outcomes. So I don't know whether it's just a little more conservative approach in Ottawa perhaps than in Toronto. How frequently, you know, in terms from a plaintiff's point of view, very rare.
I
yeah.
think it's very infrequent.
Janice,
Yeah,
never. I've never served a jury notice. Two
Yeah.
things. One, I like the certainty, but the other
Yeah.
thing is, I look at the cost factor. I mean, it just almost doubles the
Sure.
cost, and so I'm going to trial. I want to be conscious of that, even if I think I'm going to
Efficient.
win. it's still going to be expensive. I'm
Yeah.
not going to recover the kind of costs that are appropriate for it. So
Why do you think it's more expensive if for a plaintiff in terms of a jury?
It took you 40 days to do that.
I talk slow.
Yeah, but it may have been the other side.
It may have been the other side. But why would you see it as more expensive? I've never actually considered that as a plaintiff.
I just see the time of the juries coming in and going out. I used to do jury trials when I was doing criminal law years and years ago, and it just takes time. And you know, the judge is not going to sit longer than 10 till 4 or 4:15, and juries in and out. I have an objection. It should be heard in the absence of the jury.
Right.
Members of the jury, would you please, say, I'll get,
So the length of the proceeding would
Yes,
be, yeah, I think that's true.
Yeah.
Yeah.
In mediation, this comes up, because I'd say probably 10% of the cases I see, people who pull jury notices. There's a couple, first of all, typically neither of the lawyers have ever done a jury trial. That's always fascinating. Or they may have done one, or they started one and everything. Secondly, when you ask them why they pulled a jury notice, of course, the employer will figure, well, I'll get 6 retired accountants who understand this completely. And the plaintiff, well, I'll have a perfectly sympathetic person. So typically it's the plaintiff who pulls it. So I'll say, you realize you're putting your life in the hands of 6 people who just walked off the street. Oh, okay. And your whole case is about that boss, that mean and stupid one? Yeah. Well, what are the odds that at least 1 out of the 6 people off the street are meaner or stupider than your boss? The uncertainty thing, I think, plays out. It increases the uncertainty. People don't like uncertainty in a prompt settlement.
If any of you are doing it, and I encourage you to do it for a plaintiff in the right case. Justice Dan Ferguson has a great article on a lot of issues coming up in anything from jury selection to charging a jury and how your opening statement and everything. And it's really not that difficult when you read a couple of things. And the selection process is very easy. It makes no sense. It happens all in about 15 minutes, and all of a sudden you realize you got a jury. It happens that quickly. The biggest problem, if you're thinking about a jury, I think, is that how long is your case going to actually take? Because the case, the first one I did was supposed to take 2 weeks. It turned out to be 8 weeks. And every day there was a juror coming in saying, I can't do this anymore. I need to go home. You know, and you have a huge potential for a mistrial in the course of the trial if you start losing jurors, right?
Which goes to Chris's point.
Which goes to Chris's point, exactly. And you know, I think it helps if you're assessing whether to go by jury or non-jury, really how manageable your case is and the timing involved in it.
Let's switch gears a bit to the very thorny and complicated issue of the disability. The situation is that your client receives a severance package, but the package discontinues short-term and long-term disability, but it's a generous severance offer. There are currently no health issues impacting your client. The offer is open for acceptance for 7 days, as it generally is. He's been an 8-year employee, so he would qualify under the Employment Standards Act for the 8 weeks. And what happens if during that period of time your client has some form of injury which may or may not be serious and may require the disability policy? You know, the complexity of advising a client when the employer, despite the Employment Standards Act issue, is taking a position when you sign and get your generous package, all the benefits are off the table because it's a lump sum. Peter?
Take the offer and buy some insurance. I think is the easy answer on the fact situation. It's more difficult, and I represent employers much more often, and it's much more difficult for an employer in some of these situations. And I often, for instance, when I terminate the employment of a 55-year-old high-stress president of a company, I may, without the employee's knowledge, actually buy long-term disability coverage because it's not that the employer is being tough. Most carriers, as everybody here knows, will simply not carry insurance, long-term disability or short-term insurance, for non-active employees. There are a couple of insurance companies out there where the employer can, or the employee for that matter, can actually buy long-term disability insurance for non-active employees. And I've gone so far acting for employer clients where the reasonable notice period may be sort of 2 years, but there's an issue in terms of the lawsuit with the plaintiff, that without the plaintiff's knowledge, I have bought long-term disability coverage for the plaintiff just on the shot, on the chance of what you're describing, that something will happen during the reasonable notice period.
And I think that's excellent advice. I mean, this is the wild card in every termination, is the disability issue, because it happens, and when it happens, the company becomes the long-term disability insurer if they haven't complied with the Employment Standards Act, at least at a minimum, and can find themselves in millions of dollars of liability for what was a simple termination. Janice?
I don't think I have anything to add to that, other than, of course, if your client's going to take the deal, he or she's got to understand. If I've
I
got
think
my
that's
rule of
important.
thumb, yeah.
You have to understand.
Got to understand it's not there. My rule of thumb, if I'm dealing with an individual who appears ill, is that I won't settle until we figure that out. You know, I tend to say, go see your doctor. We got to sort this out first. And when we've got that sorted out in a way that, you know, as much as the doctor can give us some comfort on it, then maybe we can talk about a deal.
Chris?
I've heard nothing that I disagree with. I do exactly what Peter does with people who are getting a good settlement, is to tell them to buy insurance. I also do what Janice has suggested. I would rarely settle a case with somebody who has any kind of illness until that's been dealt with. So that's precisely what I do.
I think it's incumbent upon us to ensure that our clients have very clear and written instructions from you as counsel when you're faced with disability. I think that any reporting letter you do to your client and any discussion you have with your client around this issue is important, because, you know, many employers today do the right thing and they ensure that at least during the employment standards period that you're covered. But some employers, you'll still see lots of termination notices would say the insurance is off the table now, it may be in breach of the Employment Standards Act, and so you've got to be giving very careful advice. Otherwise, you will have, I think, a fairly serious LPIC problem.
Let me create the ultimate nightmare, because I had this mediation last week. Employer terminates employee, doesn't give working notice. I'll change the facts a little bit, doesn't matter. Actually represents to the employee that their LTD coverage will continue for the 8-week period, pays the premiums, relies on the Employment Standards Act. The guy gets sick, insurance company says, we're not bound. We have a clause that says you have to be actively employed, quotes the CNIB case that Barry was involved with, that says we're not bound by the Employment Standards Act. The Employment Standards Act is a statute between employers and employees. Does it say the word insurer there? Go to hell. The employer is left holding the bag, has become the LTD insurer if the insurer is correct. And now this happens to be a large employer, but what about the scenario where you go work for Schmo's Deli and you don't trust Schmo's Deli to have the ability to pay your insurance for the next 30 years, so that's why you really feel comfortable that somebody, life insurance company, is standing behind it. And because of something that you didn't do, you didn't do anything wrong, and your employer thought he could rely on the act, the insurance company can deny coverage.
I don't think the insurance company has a leg to stand on.
Well, read the CNIB case.
Read the
It's
CNIB
scary.
case.
Went to the Court of Appeal. The Court of Appeal said...
Read the case that Harris and I jointly lost.
Yeah, exactly. The Court of Appeal said that the Employment Standards Act, with its deeming provisions, doesn't apply to insurers. Now, one would have thought that, I wish to be a group insurer. I should be bound by the law of the land, but not our Court of Appeal. Might have even been your ex-partner.
I won't comment. We're either going to resolve that case or we're seeking leave to the Supreme Court on it. In any event, it's been a great panel. I want to thank everybody very much. The questions were terrific. We got to a few of them, and I try to cover some of the themes from the questions generally from the floor. Howard, I'm going to turn it over to you to finish with the judges panel. Once again, thanks, everyone.
Why don't one on each side? On each side? On each side. We're going to stay here. Everything's fine? Well, thank you very much for staying until the end. Now, the real problem of coming right after the senior practitioners panel is that they took away all my notes. And everything I had written down by way of introduction, all bios are gone. So there won't be very much of one. Justice Campbell was actually one of a cadre of lawyers in McCarthy in that day that Justice Echlin was speaking about early this morning when he articled. And Justice Campbell, because I articled a couple of years after this, otherwise I probably would have known that, had a very significant and varied practice at that firm. And no, that's something else. And he has just completed, I think, the Discovery Task Force, which we'll be discussing with us today, and has had quite a significant history on the bench for about the last 8 or 10 years?
No, just 5.5.
Oh, gee, okay. In only 5.5 years. Justice Archibald was a classmate of mine at U of T, and we won't talk about any of that on either side, and has taken a real interest in this area. This is his second time on this panel. I guess he was on 2 years ago, and has done a number of interesting non-competition and wrongful dismissal cases in his very brief time of about 1 year.
No, 5 years. I know time flies.
Seriously?
It's coming up 5 years
Seriously?
in January. I know.
I thought you were
I know.
kidding.
I know, so did I. I wish I was. No.
Well, having entirely blown that introduction, let me...
It's the end of the day, Friday.
I guess. I'll take any excuse at this moment. We prepared a series of questions for both of our justices today. And the first one I'm going to pose to Justice Campbell. And I guess it's the question that we all would like to ask a judge in any time we go into a case, or generically in a program like this. And I'm going to combine it both for plaintiffs and defendants, and please deal with it however you like. What should we do, and what shouldn't we do? What makes a plaintiff or defendant's case stronger in the eyes of the court? What suggestions do you have for counsel? What evidentiary foundation should be laid in preparing a case?
Well, as most good judges, you like to turn the question around a little so you can answer what you want to talk about. It's interesting what you say is what makes the case stronger. We're now in an era in which I'm sure many of you out there think that we judges don't like trials, that we're going to insist that you resolve things before because there are no trial dates and we don't like them. That's not true in my case, and I know from Justice Archibald it's not true in his case either. The problem is that our trials have become very expensive dispute resolution mechanisms. I, for one, think that there's lots of scope for issues to be tried, and in fact we can add and promote and expand the law, but we've got to do it efficiently. So when you ask the question, stronger, I say focus. And that gives me a little bit of an opportunity for a plug. On the Ontario Court's website, or if you want, you can write the Ministry of the Attorney General, you'll find two things. The report of the Discovery Task Force Executive Summary, which runs about 40 pages, or if you have insomnia, you can take the 225-page version that's, and actually one of the reasons we put all of the appendices in there with all the research that looks at things in other jurisdictions. We've got to do things more efficiently. And so when you ask how do you make the case stronger, I say know what you're doing and do it straight up. The idea that we can adversarially sit in the weeds and wait for a case to develop means that the costs outstrip what's involved in the action. And that goes everything from small claims court up to some of the biggest commercial actions. So the pitch that I want to make to you is this. I thought that the Discovery Task Force would deliver its report and fade into the sunset. In the course of our deliberations, we realized that was not likely to happen easily. There is a second phase that we're going to undertake with the encouragement of all kinds of people and bodies, and it's called the development of best practices, and it's yet to be clearly defined, but wrongful dismissal is a good place to think about it. We recognized in looking at discovery generally that no longer does one size fit all in terms of the rules of civil procedure. Different kinds of cases have different needs and different timelines. So we've recommended that the bar, with some help of the task force and the judiciary, develop some kinds of timelines, some standard productions, some standard issues to be developed, some ways of doing things that are a little different, that make sense in different kinds of cases, and that we allow for the development of a process by which they can be incorporated, if they become necessary, in judicial orders. So the first thing that we've recommended in the task force is that the bench honor agreements between counsel when they say they want to do things. So when you want to do things, I think we should be saying that's, unless it's outrageous, lawyers know what they're doing. We're going to look at the lawyers that don't know what they're doing. And so we're hopeful that good lawyers, and I say this because we need and want input from people who do know what they're doing in this step of best practices. And you start with the pleadings. They've become way too generalized, and some of the cases that are in your material, as I quickly looked at them, the judge doesn't know what they are. So when you get back to how do you make your case stronger, put it up front. If you've got a good case, let the other side know, and that goes for both the plaintiff and the defense. The suggestion that we can wait until the last to get the essence of your case out, I think, is just going beyond the pale these days. There is always room for good counsel to keep in the pocket the one or two small items of credibility that can be used if there's a trial. But we only get at maximum 5% of the cases started tried. It varies between 95 and 98% of cases started get settled. That's across all jurisdictions and across time. So we've loaded our system the wrong way. So how do you make your case stronger? As somebody said to me, let them have it in the face. Know exactly what it is with the kind of particularity that they're going to respond in kind. So that's a start and a little bit of a pitch.
Thank you. Justice Archibald, do you want to add anything?
Yeah, Justice Campbell and I were discussing that this morning, and you have to remember, much like when you're in the Court of Appeal, that the court's going to read your factum. So the factum as a trial lawyer is your pleading. And the judge is going to read the pleading the weekend before the trial commences, and will have an atmospheric conception about your case. Why wouldn't you take advantage of that opportunity by laying out your case without generalities, but with specificities and without overreach? One of the problems, as Justice Campbell has pointed out, is generalities don't cut it. It doesn't give the trial judge a roadmap at all, or any kind of embryonic understanding of your case. And you know as well as I do, you people are salespersons. You're selling advocacy. So your best points should get up front. And so your pleading is your best point. Why not reinforce from the very start, Friday night or Sunday night, if the case may be, when the judge reads the pleading, how strong your case is? That's when to do it. So forget these generalities, and secondarily, but equally importantly, don't over-embellish. Don't overreach. Don't ask for $100,000 when 20 is the appropriate amount. All right? It's not telling the proper story, and it's also giving a very bad impression to the trial judge. Lastly, in terms of putting your best foot forward, in this area, unlike most areas, there's a reasonable measurement. There are reasonable benchmarks out there. Although the law is becoming more expansive, as we all know, with Wallace and with McKinley and the contextual approach, there are still benchmarks that you can sort of get a handle as to what the appropriate reasonable notice is. So if the range is 13 to 16 months, Heaven forbid, don't be seeking 24. Because you're not going to stretch the law to 24. You're doing your client a grave disservice. All you're doing is ratcheting up the costs unnecessarily and guaranteeing a trial where your client is indubitably going to lose with cost consequences. So stop overreaching. I know by the nature of this seminar, Howard told me there were 210 registrants, which is a phenomenal number for a Law Society seminar. This is a burgeoning area. This is a terrific area to practice law, and a lot of general practitioners are practicing in this law. So just that note of caution, please don't overreach. Be reasonable as defense or as plaintiff's counsel, both in your pleadings and in the nature of the range of what you think is appropriate on either Wallace, on a bump up, or on the reasonable notice damages.
If I could just follow up on the first point you made, Justice Archibald, for either of you to respond to. I am very reluctant when I act for plaintiffs to delineate the claim to the degree of specificity I've just described, because cases evolve and I don't want to tie my hands. And I don't know what evidence I'm going to uncover before the case is out. But what I try and do, essentially to supplant the process of using the pleadings as the first thing to get before the judge, is to actually write a little bit of a script and try and present that along with opening argument. But I mean a written material similar to what you'd put before the Supreme Court of Canada at the beginning of the case. Now, the court will not have read it in advance, but they'll at least have it from the outset. What do you think of that as an alternative?
Well, it's got a bit of a problem with it, but I think as a profession, and judges are still part of the entirety of the legal profession, we got to deal with this. We addressed a little bit of this in the Discovery Task Force in terms of approach. And the idea of your being satisfied that you will get what you give in terms of specificity comes to the fore. One of the things that we're going to ask people in this best practices thing, we're going to ask the plaintiff's lawyers, what do you want to see in the defense pleadings? What do you want to know about the defense? And we're going to say the same to the defense about the plaintiff's pleadings. I recognize that there's always things that you want to know, and maybe we've got to recognize that pleadings may be more updated. One of the things that we got in the Discovery Task Force, and this is true across the common law world, and even in places where they don't have oral discovery, if people could rely on the fact that there's fulsome production of documents and of position, the whole case can run an awful lot more smoothly and at a lot less cost. So we're asking, develop what you want to do, how you want to do it. One of the things that we're going to allow for are written interrogatories, so you can ask some questions outside of oral discovery and get some answers.
In addition to oral discovery.
In addition to oral discovery, as long as it's not duplicative. Some of the things that I hope will alleviate the concerns, and I understand it, that legitimately you may have of saying, you know, I don't want to be tied down so tightly that I'm going to be dismissed out of court if I haven't mentioned X until I've had that discovery. But we're looking at a means by which you can be reasonably satisfied. But I guess the place where I would have some concern is the idea of holding back purposely for the advantage that you might get in an adversarial nature, knowing that such a high proportion of our cases have to be settled. So when's that going to take place?
Janice Payne earlier today talked about the A&P and Antonacci case, which I listened to her comments with great interest because I was counsel for the successful appellant. And I succeeded in knocking out the aggravated damages that Justice Swinton had ordered because they put a lot of particulars in but left this out. So as the Court of Appeals accepted at the end of the day, the first I really knew of the case I had to meet as found by the trial judge was when I read her reasons for judgment. And, you know, it's a real delicate balancing act.
It is.
Howard, I certainly think in 2003 there's no room for trial by ambush anymore, categorically no room. And that way, if your pleadings don't, if they're not consistent with your opening address, and the opponent wants an adjournment, he or she will almost get that adjournment from me all the time, and probably with costs. So beware that if you give these very narrow pleadings and all of a sudden in trial, your story is very different than the story that was provided at discovery, then beware of the consequences of that, quite frankly, in terms of cost and adjournment. So I just don't think in 2003 trial by ambush cuts it anymore, quite frankly, in terms of public policy.
Well, it's a tough issue because we've got rules 20 and 21 that are being invoked more and more often. And as I read the Court of Appeal cases, I mean, I can't tell you, you know, the number of ones that they continually look at Rule 20 and keep saying there should be trials until all of a sudden you see one and whoop, somebody didn't put the right word in, their case is struck out. There is a balance, but I think in terms of what Justice Archibald is saying, it's really important that the court not think that somebody is hiding something for the purposes of trying to get an advantage later. And I think the way that you can do that is anticipate what it is you want through the discovery process from the other side.
Well, that's how I've always viewed it. I'm not talking about hiding, I'm talking about making the pleadings very general. And then it's up to the other side to extract the information relevant, and you've got to give full disclosure within the spirit of the questions, not just the substance. But if they don't ask questions that are at least, frankly, fall squarely within the pleadings, in my view, it's their tough luck. You don't think so, I'm gathering.
Well, it may be their tough luck.
Which way are you talking, though? Because there's two sides to that. Are you talking about not wanting to reveal the case that you're going to make against the other side that you know you're going to make, or not wanting to reveal the areas in which you want to extract information from the other side for the purposes of making your case?
Well, I think it evolved. From its inception, it's simply wanting to leave your options open because you don't know what the case is going to evolve into. You have some generic idea, but you don't know precisely how it's going to arise. But at the end of the day, as it's developed, if they don't ask questions, the questions are squarely flow from the pleadings, there's nothing surreptitious about it, there's nothing devious about it, then I really think we're still in an adversarial system. It's the other side's tough luck.
Well, let me ask you a question. Because we've got all of these processes now with rules, particularly Rule 77, and if you haven't read it, a lot of people haven't read it, you should read Rule 77. That's case management rule. Let me ask you a question. When do you think is the point in time in which all of the cards of disclosure should be on the table?
When the rules require them to be.
Well,
You're asking me my opinion.
That's
fine.
how well, that's good, because that fits with one of the recommendations in the Discovery Task Force that's going to say the settlement conference date is the date at which expert reports, everything should be out and on the table, because I find as a judge who does an awful lot of the settlement conferences that we get into these things and things are popping up, and the settlement conference or pretrial date is supposed to be very close to the trial date, and this is where the costs come inordinately disadvantaging one side or another, because inevitably, as Justice Archibald says, there's going to have to be an adjournment. So the aim of what we're doing with this whole of this best practices, and I can live with up until the settlement conference date, but I guess I'm now seeing things somewhat differently than I did as a practicing lawyer, that we've got to ensure that the surprise element, the ambush element, is gone. How you do it may be an open question, but what's going to be done should be on the table.
See, Howard's example, of course, is the extreme example in the sense of assuming that counsel asks all of the questions, but the one key question isn't asked, of course, there's no obligation on Howard's client to divulge that unless it's that side of the coin that Justice Campbell was referred to, the positive obligation. But that's a rare circumstance. So I agree. If you take Howard's example where on a principled basis, with no surreptitious and no kind of cleverness by half approach, you don't disclose something because it wasn't asked, then no problem. But the reality is, as soon as it comes out at trial, the opposing side is going to squawk, quite legitimately so, and Mr. Levitt will get up and say, well, they never asked that question, did they? And then you're going to spend an hour and a half, if not 2.5 days, on a motion before a trial as to whether or not it should have been disclosed, whether the question was properly asked, whether it wasn't properly asked, discovery. An adjournment will probably flow from it in any event. There may be cost consequences. So I think there are dangers even in the idealistic example that you've given, Howard, quite frankly.
I find the idealistic situation comes up quite regularly, actually. People aren't perfectionists. Lawyers aren't perfectionists. Lawyers mess up. They forget to ask things. They get lazy. It's not that infrequent. There's a question.
I just wanted to clarify. So perhaps taking the employment law context, best practice might be that if we have a more general pleading that pleads bad faith, a statement claim that pleads bad faith, and we include some examples, but we go to discovery and we formulate our theory of bad faith with more particularity, that it would be a best practice to ask for a consent amendment to the statement claim to particularize further what additional grounds of bad faith we're seeking.
Yeah, there's a number of ways of doing this kind of thing, and I think one of the things that we wanted to see out of this, and I understand even since we've started the task force, some of the law schools and other organizations are running courses on discovery. I mean, when we started this 2 years ago, there was not a formalized course on how to conduct an examination for discovery anywhere. I mean, one of the ways of doing it is an open-ended question on discovery. You've pled bad faith. Have you given me at this point in time all of the facts, forget material facts, all of the facts that you're relying on in support of the allegation of bad faith? What do you do with that, Mr. Levitt?
I think you'd have, well, it's interesting. I just asked that question in the province of Alberta last week, and I was told there was a case there right on point that you can't ask that question. That was in the context of, is there anything more you have to say about paragraph 3 in your statement of claim, and so on. So, but here...
Depends how you frame the question.
Sure, but here I would say that you're at real risk if you don't give all the facts you're relying on, and if you think of others later, you have a continuing obligation, obviously.
And I think that's, I mean, what we don't want out of this process is to get back into a fight that used to take place when I got called to the bar. I used to love to do pleadings motions, but people could afford them back then. We can't afford to be fighting before a case management master or a judge about pleadings anymore. We've got to come to some consensus on what you can expect and what you should do. It's going to be a little problematic, but that was one of the reasons I asked that question about those jurisdictions in which there is no oral discovery, England, New Zealand, and Australia. And interestingly enough, they get into more fights on pleadings. So there's a bit of a trade-off there.
Howard, I just make a comment. Well, I think I agree with you, Justice, that in terms of the level of disclosure should be, and the position should take place as soon as possible. But the bench also has a role in the course of the trial to not let parties do that. I had a trial that had 76 motions in the course of the trial, and with reports still being submitted, and the way it was dealt with was simply that, well, is there any prejudice? Do you want to delay? Do you want an adjournment, or do you want costs, or whatever? And generally speaking, my interpretation certainly of the rules is that unless you can show prejudice or cost, then usually the judge is going to allow that to happen. And you really, I think as counsel, you really need to absolutely agree with you. The sooner the disclosure, the better, and I can't see any reason why, beyond the discovery stage, if there's any guessing that still goes on. Both parties should know what their case is at that point. But in the course of the trial, where counsel are still trying to produce reports and amendments to their pleadings, it's outrageous, right, that counsel still try to do that. We need the help of the judge who's managing that case.
Well, hopefully we'll get the support for that through the rules first. Two of the recommendations that we've made is to amend Rule 26 and Rule 5302, both of which use the word shall. The trial judge shall admit the report of an expert unless it's satisfied. We say reverse the onus and put it may. And it's a small signal, but it's one, and we are suggesting in saying that the disclosure time is by the settlement conference, we're looking to say to everybody at that point in time, you better not count that you will get leave, that you, beyond that time, you need leave for amendments to pleadings, and the shall goes. So hopefully that will be taken up, because you're quite right. I think that's one of the significant costs of civil litigation, because there's a lot still going on of people trying to one-up at the last minute.
You know, I have just, in the context of a judicial review application, I just read some interesting decisions of the Supreme Court of Canada, both in the civil and criminal context, and I think there could be some natural justice challenges to any restriction on adding new grounds on either side at any point.
Well, it sure is from a cost point of view, I can tell you. Becomes the case is so different, and I do mid-trial pre-trials as well. The cases end up being so fundamentally different that somebody who could and would have settled at X dollars earlier on or done something has their whole life changed, and their expectation is totally different, and they had no notice of it.
No question, there's significant cost consequences, adjournment consequences.
Absolutely. So I think you're right, but that's one of the reasons that we decided to engage on each of the little task force, or however we organize this, on this best practices. I have asked already a number of judges. Justice Echlin has indicated that he's prepared to assist. So in each of these areas, you will be able to get to the judiciary as well as the profession.
My second question of the 12 I had for today, which I think we've just agreed as we were talking to whittle down to 4, is how predictable do you find employment law to be as of today's date? You want to start?
I think it's still reasonably predictable, although, of course, as we all know in this room, as you've spent today, there are ways where it's becoming more expansive. Of course, MacKillop, for example, the whole idea that you take a contextual approach to the alleged misconduct of the employee to see whether it goes to the root of the employment relationship. Well, if you take a contextual context, that means you're going to trial, in essence, because it's in the eye of the beholder to look at the context. Now, I know the SEC didn't mean that, but again, when you look at that whole kind of public policy analysis in McKinley, it does sort of establish to some degree the element of, well, each case should be assessed on its own merits, and you shouldn't sort of take the case law from over here and try to pigeonhole it into the case law over here, of course, to some degree. But still, as practitioners armed with McKinley, you should be in a very good position to assess whether or not the alleged dishonesty goes to the center of the employment relationship. All right, so as practitioners armed in the law, you should be, by and large, in most of the cases, except in the real gray ones, in a very good position to advise your clients concerning the appropriateness of settlement. Again, in the range now for reasonable notice, as you know and as you have probably discussed today, in terms of the upper limits for management and executive. It's pushing past 24 months now into the range of 27 and 28. And of course, for non-managerial employees, 12 months was kind of the ceiling, and now it's pushing past the minute standard. If you look and rely upon Bramble in the New Brunswick Court of Appeal, for example, maybe 13, maybe 14, maybe 15 months for non-managerial employees for the ceiling. But again, that's still a range, and it's still reasonably comforting and reasonably within your ability to still quote a range. No longer is it 9 to 12, maybe it's 9 to 15, but you can still settle your case. Wallace, of course, has added another gray element to it in terms of that. But again, Wallace is still pretty clear. You have to have bad faith in the dismissal itself, not yet bad faith in terms of the employment relationship. That's a totally different issue. That's evolving. But in terms of Wallace, you still, as good practitioners, should, by and large, be able to put a handle on whether the Wallace bump up is 2, 3, 4, or 5 months, as opposed to 2 months versus 5 years. If it was 2 months versus 5 years, every case would go to court because you'd have grave uncertainty and no counsel would know, of course, how to settle the case. So yes, is it becoming more uncertain? But at the same time, there are still, in this area of law, very significantly reasonable benchmarks that well-armed practitioners will be able to use for the purposes of settling their cases, as opposed to having to necessarily go to trial to have a trial judge put her stamp on whatever is the appropriate judgment. Thanks, Howard.
Can I give a little more cynical view? I don't disagree with anything that's been said, but I make the presumption when I come to something like this that the people that are here are good practitioners, and I say that with some assurance because the people that I see don't come to, some of the people that I see don't come to things like this. The cynical view would say that McKinley, Wallace in particular, have given more scope to those who don't know what they're doing to try to push and suggest that they're going to get the limit. And the problem that I see it regularly, is that some of these people have told their clients that they can expect more than the reasonableness that Justice Archibald's talking about. So one of the things that you people have to do as good practitioners is come armed when you know that somebody on the other side may not have the background and expertise that you've got, to get them into the talking range, because I see some of these settlement conferences and somebody says, I want years on Wallace factors or whatever, and unfortunately they've spent so much money, their client's expectation is so high, it becomes a very difficult, if not possible, case to settle. So in one sense, the reasonableness is still there for good people, but I do have a concern that the open door for uncertainty, and I think we may need some further decisions, Court of Appeal particularly, to confine it to where we know it should be. Yeah.
Regarding the issue of Wallace, it would certainly make life easier for practitioners as well as authors of databases if the judiciary would differentiate between reasonable notice and the Wallace bump up. And there was, I think, at least one Court of Appeal decision that said you shouldn't do that. It should all be an amalgam.
I know.
And I simply suggest that predictability is tough enough, but at least if judges consistently said reasonable notice is X, the bump up is Y, we could get a better sense of how much the bump up is.
Totally agree with you.
It's a question from the audience.
In the area of constructive dismissal, one point in which I find it difficult to explain to clients because it's somewhat counterintuitive, I have to explain to them the concept of mitigation. Even if they are right about the constructive dismissal, they've got to march back into that job that they just thought they were constructively dismissed from. Of course, the Court of Appeal case in Nixon is still the leading decision, but I'd like to hear from perhaps senior practitioners and our jurors as to how seriously the court will in fact enforce that law, suggesting that someone's going to go back, despite being constructively dismissed, to mitigate their damages into an environment that they consider to be perhaps somewhat abusive, and there's a lot of gray area in that.
You start.
Me? Okay. Well, I don't think it matters how they feel, because what the Court of Appeal has said is that subjective perceptions or apprehensions of the employee is irrelevant. But objectively, if it's an abusive environment, that's precisely where MIFSUD does not apply. Because what MIFSUD says in its own language is if the relationships are not acrimonious, if it's reasonable in the circumstances. And it also notes if there's no reduction in remuneration, although I wonder about that, because I can't see why a slight reduction in remuneration would exclude the MIFSUD principle. There have been other cases where there has been a slight reduction in remuneration, and the courts have said the employee should have remained to mitigate. But I think acrimony or abuse is precisely the circumstance and precisely the differentiating circumstance that between what MIFSUD applying and MIFSUD not applying.
I just say, what case do we know of where they're litigating and there isn't acrimony? If there wasn't in the first place, there certainly is after.
Well, if they're litigating, of course it's acrimonious. But the question is, where MIFSUD comes in, is if they are offered the job back and they don't take it. If they take it, it's not likely that there won't be an issue at all. If they don't take it, then they litigate, and the court will say or may say, as per MIFSUD, they should have mitigated, therefore they're disentitled to damages.
I think Howard is drawing the line carefully in the sand in terms of your question. I think that's exactly where you draw the line.
Howard, can I say one thing? I think that as counsel for a plaintiff, if you're going to allege constructive dismissal and advise your client on that, you should be really, really, really careful. Because I see it a lot where there's some type of dispute in the employment relationship, and a plaintiff will go to a lawyer and get advice that it's a constructive dismissal, and they come in and they ask for a package and they don't get what they want, and they just walk out and allege constructive. And I had one like that last week, and it is very difficult to win those cases. And because I think that generally what I've seen is that there's lots of leeway that courts are giving companies to make minor changes, and there might be some dispute, obviously, some acrimony, but there's got to be a serious amount of acrimony, I think, to prevent the employer from getting the employee to go to another job. And I think it's such high risk as counsel. Howard, don't you think? In terms of
I think MIFSUD has almost destroyed constructive dismissal cases as a practical matter. If you're fired, you don't have a choice. If you don't like the severance offer, you have to sue. There's nothing to lose. But if you have a choice between continuing to work and resigning while having no money, suing, having to incur legal fees, potentially have to incur the costs of the defendant's legal fees at the end, for something that's as speculative as what constructive dismissal has become, we as counsel had better be very cautious about the advice we give. And I will never let a client take that course of action unless they say, I don't care what you say, Levitt, I'm quitting anyway. And then I make sure that's in writing, at least by me. Yep.
I've dealt with that situation before as plaintiff's counsel, and I find it a very effective technique in order to avoid the condemnation problem of where the employee either doesn't want to take the risk of walking and calling it a constructive dismissal, is to have the employee write a memo to the employer saying, look, I consider this to be a constructive dismissal. I'm going to stay here, I'm going to work it out, but I'm putting you on notice that I may be suing you in the future for damages. Not too many employers are going to keep that employee around, and you'll have a clean dismissal, and yet the employee's been protected. That tends to work fairly well.
Or simply have a lawyer write the letter. It's even more likely to get the person fired quickly. Sorry. Yes?
Is your view that that's costly, the writing of the letter?
I don't think that. There have been a couple of cases involving fiduciaries, and including a Court of Appeal decision where that's been held to be cause, and I think it was asserting a patent right that the court said the employee didn't have, and it was a breach of their fiduciary duty to assert that right because they didn't have it, and it was the president of the company. Helbig and Oxford Warehousing, I think was named the case, about 10 or 12 years old. Helbig, H-E-L-B-I-G. There's a tech firm involved as well. In any event, it's a real, other than that rather anomalous circumstance, I don't think there's a realistic risk. There's got to be some assertion that's realistic of a violation of fiduciary duty, and in the garden variety wrongful dismissal case, somebody asserting a legal claim isn't going to be that. And there's also got to be some serious public policy arguments against penalizing employees for asserting at least an arguable legal right. Wouldn't you think?
light of the fact to avoid an argument that there was a Wallace factor. And I'm just wondering do the judges care? I mean, I would have thought that if the employer wants to show that they're reasonable, they should pay the money. So if they walk into court and say, we think reasonable notice is 12 months and we pay 12 months, and the greedy guy over here thinks it's 36, that's fine. But what I find, at least, is lawyers are pleading, well, we think reasonable notice is 12, we offered 12 when we signed a release, we only paid them 8 weeks, but you should take into account our offer. And I'm just wondering whether you've seen that, and are you impressed?
Well, I mean, I have, particularly at a settlement conference, and my standard line is, put your money where your mouth is. And it works, we get settlements.
The flip side of that is, are you going to be more apt to find an employer reasonable if you walk into court and you found that they've paid reasonable but cheap notice, but at least they've paid it, as opposed to an employer who just paid the employment standards and then still tries to say low end of the notice period?
Well, the trouble is that in a trial, you don't find that out until, if you find it out at all, until right near the end. So you've heard a whole bunch of evidence and formed some at least preliminary conclusions on things. That is, as a trial judge.
No, I'm assuming that if the employer walks in and said, "This is a case of reasonable notice, Your Honor. We've already paid the gentleman 12 months, and the other ones, and therefore we think 12 months is reasonable," as opposed to the next trial said, "Well, the 12 months may be reasonable. We've only paid him 8 weeks, but that's the game. I've actually heard that. Why would we pay him if we're litigating against them?" Is that going to be viewed by a judge one day as a Wallace tactic? You know what reasonable notice is. You refuse to pay it because you want to pressure the plaintiff.
Well, I think, I give you a strong judicial maybe. I think it depends. I mean, is the plaintiff saying that he should get 60 months notice and aggravated damages of $200,000 on top of it? I think you have to wait and see what comes up before you know. I'd want to know what the plaintiff's position is. If it was the plaintiff said 14 months and the employer said we paid 12 months, I'd say I'll find Justice Archibald for you for a few minutes before we continue the trial, because that just doesn't make sense. So I think you do need a little context.
I mean, yeah, let's follow up though. You have to look at it from the imprint of reasonableness, don't you, in terms of a negotiator. You don't look at it from the point of view, nor should you, of hardballing or trying to play the deuce of spades when the 10 of spades should have been played, all right? So if 12 months is what's reasonable and the employer has only played the ESA, in my respectful view, depending upon context, there's a really good chance that the employer at the pretrial is going to look rather parsimonious and lowballing purposefully for the purposes of negotiating the settlement. So I think if what Justice Campbell said at the start and what I said, if you're supposed to approach this from a reasonable perspective, from a fair bargaining perspective, then I don't think you should be lowballing, and nor do I think if you're plaintiff's counsel, should you be starting off at 60 months when the thing's worth 18, all right? So if that's of any kind of measurement for you, so I don't think if I was an employer's counsel, categorically, and it's worth 12 months, would I ever just pay the ESA? I might give them 6 months so I can get the negotiations going, but I sure ain't just gonna pay him the ESA, because that's way too low. That's below the floor, if you will, and not appropriate. And it's gonna benchmark the negotiations on an unreasonable footing, and I'm gonna look cheap.
No, on the other hand, I do come from enough of a defense background that I recognize in lots of cases that the payment of money just put money into the hands of the plaintiff's lawyer to fight harder. So that's why I come back to a context, the creative things done that pay money over time does various things that without putting somebody in a position that they now have all the more reason to try to squeeze the last cent out.
You're absolutely right. Corporate clients always say we don't want to fund litigation against ourselves, and that's where it ultimately comes from. But there have, in fact, Barry, been cases where Wallace has been applied because the employer only paid ESA.
Yeah, I know.
And I would think the employer should have the right, if you can't negotiate a deal, that the employer should have a right to see how mitigation works out.
But then that's right, but then what if it's 2 months have gone by, 3 months have gone, you know how mitigation's worked out.
Then arguably that should be paid if it's a question.
I mean, this is the whole problem with Wallace, as Justice Archibald said earlier, is the reasonableness. I can tell you one thing that we don't want to get into as judges, whether it's at settlement or conference or at trial, is to all the negotiations that went on. I mean, if there is some suggestion of clear, demonstrable bad faith, then get it out. I mean, I see this regularly in the motor vehicle field now, where all the insurance claims are with the accident benefits, and there's arguments if you don't pay everything, it's all bad faith. There's a real concern on my part that it looks like a make-work program for somebody. And so yes, there are going to be cases, but I would say to everybody on either side, choose your case, choose your issue well.
I'm going to go on to the next question now, but maybe the questions that a couple of people still had will be pertinent. How subjective is Wallace? Both in how it will impact on different judges? Is it a bit of a crapshoot that way in terms of how broad the range is, in terms of what type of conduct might qualify? How subjective is it?
I don't know, because I see the same lump sum things that you're talking about. You know, we're talking 22 months, including Wallace factors. How do I know? I would like to think, and my experience recently has been more in the settlement field, and is trying to break it out. And I'm looking for some guidance to try to make it more objective. That's why I think ultimately, and presumably at the Court of Appeal level, we need some more help. Somebody's.
Are you prepared to take mitigation out of Wallace?
Court of Appeal says you can't do that right now. But let me back up just on this question firstly about not the amount of Wallace, but whether or not you're entitled to the threshold, getting in the door of Wallace. It seems to me we see it way too often, every pleading now, let's plead Wallace. But the reality is, it's a very high threshold. People seem to forget that. I mean, the Supreme Court of Canada in Wallace used some language which is fairly stark, something akin to the blatant disregard of the employee's relationship with the employer, unfair dealing, bad faith, malice. I mean, you've got a Court of Appeal case in Ontario, Gisman versus the City of Toronto, 2003 OJ number 1490, that talks about what you need to found a claim for Wallace, and it's a very, very high threshold. So firstly, is it subjective? Sure it is, but it's high enough up that most cases aren't going to get through the gate. That's number one. So as plaintiff's counsel especially, take a hard look as to whether or not your case meets the Wallace threshold, because if it doesn't, that's going to negatively impact on your entire case, on your entire presentation. It's going to take away a lot of the persuasiveness of your entire presentation. But once you get in the Wallace door, I agree, then you're into the subjective aspect. Is it 2 months, 3 months, 4 months, 5 months, 6 months? And it's pretty loosey jelly right now concerning what it is, and it is more speculative in the eye of the judicial officer concerning how bad she thinks the offer is. I mean, the malice is. But in terms of mitigation, you got the Princeau case that says, on a principle basis, whether you agree with it or not, Princeau versus Baycrest Center for Geriatric Care, 2002, 60 ORs, Court of Appeal of Ontario, saying you can't mitigate Wallace damages because they're bad faith. And it wouldn't be fair to the plaintiff to effectively denude her compensation for the specific injury done to her by taking away mitigation, by subtracting the mitigation from it. So there it is.
If Wallace damages is for humiliation, etc., and Ms. Prinzo made $30,000 a year, got $15,000 for being embarrassed, because why does Joe Smith, who makes $150,000 a year, who's equally embarrassed, get $75,000 on his bump up? Aren't we mixing apples and oranges? Why do people who make more money get more money if they're humiliated? If Wallace damages is really tort damages, then shouldn't we look at it by the victim, not based on the salary the person had to make?
But isn't that the age-old distinction about non-managerial employees versus managerial employees in a different context in terms of reasonable notice ranges?
We're not
It is worse, I agree.
We're compensating people for humiliation. Who's to say, and it's like general damages in a tort claim. A doctor doesn't get more pain and suffering damages than a receptionist if their heads go through the windshield. But that's exactly what we've done with Wallace, because we've mixed up tort and economic loss. That's my question.
I agree with your question.
Well, make sure you argue that well in the Court of Appeal, and we'll get that thing resolved.
I've got a couple of questions in from the computer world, and they go as follows. And I'm going to combine them with actually a question that we had already. How do you deal with counsel that are discourteous to each other in the conduct of a trial? And do you see a decline in lawyer courtesy over the years? I'll start with you.
Well, not since I was part of the committee of the Advocate Society that dealt with the principles of civility. That's how I got on that. I didn't bring it today, I should have, I saw the question. I carry that little pamphlet on the Advocate Society Principles of Civility into court with me every time. And I think, quite frankly, things are getting a little better. Or maybe I'm getting a little better at handling anything. I don't have a problem in my courtroom. I one day, with some bickering that didn't stop, walked out. They were still talking when I left, and I sent the CSO back in to say, when they've stopped, I'll come back in. It worked, and nothing happened ever since. I think that to a large extent it's a judicial function of knowing the lawyers and knowing how to control the court and getting the rules straight. And quite frankly, I just don't see it as a problem. I insist on the proper steps being taken. I started out because I wanted to get through cases and things and letting people talk, and I saw that it was causing a problem. Somebody and it's a lot of it are guys that are my age or older, think that they've got some right because they've been honking for years that they can continue to do so, and there's just absolutely no way. And I think that if that's happening to you, and I say this particularly to the young lawyers, have the courage to stand up to the judge and ask the question, is this the way I'm going to have to respond? Because I think you'll get a good reaction from a judge very, very quickly. All of us are concerned. It happens more in multi-party cases, I found, when they're fighting amongst themselves than just a two-party case. But again, I don't know what you think, Todd. I think it's the judge.
Well, I agree. I mean, since January the 8th of '99, I haven't had a problem either. But prior to January 8th of '99, I had lots of problems at discoveries where I would have bully counsel trying to pick on me and try to throw me off the discovery trail. Most often it didn't work. Sometimes it did, depending upon the nature of the aggression, I suppose. But the civility, the advocacy work that was done by Colin and the Advocacy Society was trailblazing in terms of reminding all of us that we are professionals and the wonderful obligation that we have as lawyers. I mean, the reality is this: as judges, we're not going to see it. We're just not going to see it in front of us. I mean, only a foolish counsel would do that in front of us.
There are some, though.
Yeah, that's right, who wants to lose, and most likely will lose the case. If not this time, the next 10, for sure, because we'll go back to the Martin room at lunch to discuss how odious this particular counsel was. So he or she has a very short shelf life. But at discovery, regrettably, this still continues, and there's many reasons for it. Too many lawyers, as we all know. I don't mean, I'm being somewhat facetious, but a lot more lawyers, a lot less cases, a lot less mentoring, economic realities, docketing, all of that is part of the pressures we have all faced. But the great things about the civility canons and the law societies promulgated them, all of the continuing legal educations like Howard and Barry have put forward, all of that is helping all of us to get past that and to fight cases based upon the law and good preparation as opposed to using bluster, if you will, and aggression to fake it. So I think it is dying down, but of course, it is still going to continue, as it always will, when you have lawyers who are either ill-prepared for whatever reason, in a rush, don't have enough economic support to put any time into it. It's going to be there, but thankfully, there are these canons that are developing.
Another question from outside, and really, you prefaced it, Justice Archibald, by talking with the Brambles case from the New Brunswick Court of Appeal, which I commend to all of you to read. It's a very intelligent decision dealing with a lot of interesting employment law issues. In any event, the question is, how much credence or weight do you give to cases from out of province, in notice or in cause or in anything? I'm not talking about both at the Court of Appeal level in other provinces and at the trial level.
Well, you know, they're a persuasive value, right? I mean, the Ontario Court of Appeal was binding on all trial judges in the province of Ontario. There are some strict legal scholars that would say that the British Columbia Court of Appeal or any other court of appeal, the appellate authority, is also binding on us. But there are other legal scholars who will say the exact opposite. It's an interesting constitutional, quite frankly, legal argument. Certainly, Court of Appeal decisions from that are not in opposition to the Ontario Court of Appeal are of significant persuasive value to we trial judges in Ontario. And of course, every SEC decision is absolutely binding in all cases.
It's a good question, and I'm trying to put it into the employment law context from where I often see it in the tort damage context. And again, you'll get a great big judicial certainty, it depends, but I like to look at something about who's done it, and in the context of when they've done it. We know if you look at tort damage awards in the Atlantic provinces, they're less than they are in Ontario or BC or Alberta. And my sense of it, not having done a study of this, my sense of it is that notice periods tend to be less. I don't know whether somebody might be able to help me, but my intuitive guess is that they are a little less generous in the Atlantic provinces. And so I try to put it into context with where they are and their issues and then apply it. Can anybody have?
I think that, well, Barry, you did a study. You may know the answer, but
Yeah.
my impressionistic thought on that is that they used to be, and Brambles, in fact, made that no longer the case.
Okay.
There used to be a 12-month limit in New Brunswick specifically, and
Yeah.
that was the
Yeah.
law
Yeah.
by the Court of Appeal. And I find the case, I've done a lot of work in actually New Brunswick, Nova Scotia, and I find that the awards are just as high as here now.
Okay.
Over the last 5 years.
So that's the context in which I'd want to know. Where are they within their own regime?
Like, you know, there's an example. Minute and O'Shanter conflicts with Bramble. So what authority are you going to follow? In Ontario, of course, Minute and O'Shanter, as far as it applies concerning the ceiling, if you will, the alleged ceiling for non-managerial employees. Bramble punches up the ceiling significantly. Minute is still more conservative. So in Ontario, Minute is going to have a little bit more persuasive value, rather obviously, 4 years old, that decision, as opposed to Bramble, which is 2 years old from New Brunswick.
And Cronk even less.
That's right, which is 6 years old now.
Right. Any comments on that, occupational status as determinative of notice?
Well, I'll just give you one thing as somebody who's now over 60. I do have a soft spot for the individual, and it depends on their age and what they are doing that becomes unemployable in a virtual sense at whatever time that takes place, and we're seeing that. Actually, I think we're going to see it change back the other way, but if you look back to when I first went on the bench and I started to see friends of mine, my age at age 54, 55, that were being terminated, and I could see, depending on what their background and whatnot, that they would become unemployable through no fault of their own. You know, each of us carries one or two little small things that it's not going to greatly interfere with what I do, but there are things like that. And you look at the educational background and whatnot, they all, that's back to McKinley.
So you look at reemployability, whatever the context is.
Absolutely.
Whether it's vocation or age or salary or.
Yeah.
Justice Archibald?
I guess that sort of brings us to the point of always, if you're going to trial or at the pretrial, know your judge. know the background of your particular judge, where she was a lawyer, look in the OJs for the cases that she or he has decided. Get a sense of where this judge, what the sort of human parameters of the judge are. And of course, that can only help you in terms of your pretrial negotiations. And at trial, the same would apply.
One last question.
I actually have two questions, if you don't mind. One is your view of the strategy of commencing legal proceedings in a constructive dismissal context when the employee is still working. And number two is the effect of a non-comp or non-compete agreement on notice.
Not non-solicitation, non-compete. I'd have to know more about the non-compete.
Presumably you're saying they can't work in their industry. Does that increase the notice period? That's the question? Okay.
And you're assuming it's a legitimate, sustainable non-compete?
Or at least one they abide by?
Yeah, no, but abide by. Well, I think that, given that premise, that does affect notice to my mind, you know, but all of us are getting concerned about non-competes because they were overused for a while, but there are contexts in which they are still very important and very useful, and if you've got somebody that clearly knows what they're doing, signs on to it and all the rest of it, I tend to think there's an obligation on the employer side.
So could notice go is for the period of the non-comp? So it's a year or 2-year agreement?
Yeah, it depends, but that doesn't offend me.
Sir Archibald, do you want to
I
add
agree.
anything?
No, I agree. We know the Lyons and Malteri case deals precisely with non-comps versus non-solits, and then you got non-deal clauses too these days. But I think that makes very good sense from a philosophical point of view, that if you're going to restrict the employee quite significantly from making an income, and that's one of the rationales in the employment law context, isn't it, to make sure the reasonable notice is sufficient to allow him to get back on his feet. Well, if you're preventing him specifically from getting back on his feet because of the non-comp, why shouldn't you be in a position parallel-wise to have to pay him for it? I like the point.
No, much earlier today, and at the end of the mediation session, I said that we're going to have to, in formulating this program in future years, make it more interactive. And this session was a great example of that. That was just fabulous material, and thank you very much. Thank you all for staying through the whole day.